strongly interdisciplinary and includes work on law in African literature, African history, legal education, and women in the law. She has a strong research and professional interest in land law and development, and this is evidenced through a recent publication. This is evidenced through a recent publication, and a recent book is The Struggle for Land and Justice in Kenya. It appeared in Eastern and Southern Africa paperback, which was published by Vita Books in 2021. The book was a finalist for the US African Studies Association and the Best Book Prize in 2021. The reviewers of the book noted that it is innovative and path-breaking, both in its multidisciplinary examination of Kenyan's land law issues, as well as its ultimate experimental conclusions. In 2023, it was a runners-up for the African Studies Association of African Pius and Desnam Memorial Prize for Excellence in African Writing. Professor Brina is also the president of African Studies Association in the UK, where she served between 2018 and 2020. She's the editor of African Affairs from 2019 to present, and she is a member of the governing council of the AHRC, where she served between 2020 and 2026. In addition, she's a visiting professor at UCD Sutherland Law School, a member of the research committee of the British Institute in East Africa, and a member of the International Scientific Advisory Board at Max Planck Institute for Legal History and Legal Theory between the period 2022 and 2027. She has been invited to teach classes in law in Nairobi, Johannesburg, Cape Town, Dakar, Addis Ababa, and Bogota. Welcome, Professor Brina, and such a pleasure to have you on the panel this evening. Our third panelist is Miss Sheila Minka-Preno, who is a senior lawyer, development consultant, and a human rights activist. She holds a law degree from the University of Ghana and was called to the Ghanaian bar in 1989. She also holds a Master's of Law degree from Georgetown University Law Center in Washington, D.C., in the United States of America in 1995, where she studied as part of the Leadership and Advocacy of Women in Africa, the program popularly known as LAWA. She is the managing consultant of ALC Law Consult, a law firm that is based in Accra that provides legal services in civil law. She's also a development consultant and been involved in research and the preparation of a number of policies on gender. She's the first president of the Women's Forum of the Ghanaian Bar Association and belongs to several human rights organizations, including LAWA Ghana Alumni Incorporated, African Women Lawyers Association, and Zonta Accra too. Our last panelist is Nyokabi Njogu. Nyokabi Njogu is the legal advocacy advisor at the Center for Reproductive Rights, where she undertakes legal and policy advocacy to advance reproductive justice across the continent. She is an advocate of the High Court of Kenya and an alumni of the Feminist Litigation Institute of the Initiative for Strategic Litigation in Africa, and Nyokabi's work focuses on the intersection of law, feminism, and social transformation. She has over 14 years of experience where she has spearheaded strategic litigation and advocacy initiatives that have shaped national and regional jurisprudence on women's socioeconomic rights. Her expertise lies in leveraging constitutional and human rights frameworks to secure women's access to quality sexual and reproductive health services, essential medicines, and justice for violation of reproductive rights. Nyokabi has designed and argued precedent-setting cases before the Supreme Court of Kenya and the High Court of Kenya, contributing to groundbreaking decisions on women's access to property and upon dissolution of marriage, state accountability in the provision of health services, and protection of reproductive autonomy. Through a feminist approach to the law, Nyokabi has consistently centered women's lived realities in litigation, policy processes, and ensures that legal victories translate into meaningful social change. Welcome, Nyokabi, and welcome all again, our audience. We are glad to have you this afternoon. And today's webinar is focused on gender neutrality in law and the issue of division of matrimonial property. In some legal systems in Africa, the law requires that upon dissolution of marriage through divorce or judicial separation, parties to the marriage are entitled to the matrimonial property in accordance to the approved contribution that was made towards the acquisition of the matrimonial property. While this law generally appears to be gender neutral and harmful and realizes the principle of equality, to the extent that it seeks to treat both parties to the marriage equally, it is a concern because it amounts to indirect discrimination of women given its application within the social and marital context. The lived realities of marriage reveal persistent gender disparities because of the failure to recognize an equal power dynamics in the relations between husband and wife, and more particularly the social and cultural structures that have put in place gendered roles within the family and relations within the home. And particular concern is on the issue of women's lack of economic empowerment. Many a times, despite having contributed significantly through non-monetary contribution, most women in Africa are not able to access equitable share of matrimonial property upon divorce. This is because, despite the law being gender neutral, women face the horrendous task of proving the variation and the existence of the non-monetary contribution, and the courts have grumbled on the question of quantification of such non-monetary contribution. Most importantly, when Maputo Protocol was enacted and adopted, it adopted Article 70 of the provisions of one of the provisions of the protocol, which guarantees an equitable share of joint property among parties. Despite this provision has continuously being of concern to family law practitioners within the African continent. This is because of its vague wording that has left many uncertain implications on its application and meaning within the African continent. There's been so many attempts that have been painfully slow, and the fight has turned into a battlefield where women have to contest for a share of equitable provision or equitable share of matrimonial property upon divorce. Some of the processes that have been carried out within the African continent continue to be the strategic litigation, where women have actually gone to court to assert and to have the court give meaning to the meaning of equitable share of matrimonial property upon divorce or separation. One of such cases has been the case of Frida Kenya versus Attorney General of the Republic of Kenya, which is Civil Appeal number 238 of 2018. This case particularly challenged the constitutionality of Section 7.
Il y a des cas, en fait, qui challenge
This provision provides in a nutshell that parties are
la
entitled
Constitution.
at the end of the marriage to the matrimonial property per the approved contribution. At this point, then, I will call our first panelist.
Donc, à ce point, je vais appeler un autre panéliste qui va parler à ce sujet qui a été mêlé, qui a pris part au cas. Donc, nous voulons savoir quels sont les problèmes légaux auxquels on a eu à faire face.
Thank you, Caroline, and thank you for convening us for this critical conversation at a time.
Merci, Caroline, Carole, de nous avoir invités sur l'équité des genres. Donc, le cas dont tu as parlé en général, il y a une, en fait, organisation société civile. Donc, c'est par rapport à l'article sur les droits matrimoniaux.
Prove their contributions in order to get a share of that property.
Vous savez, dans cet article, il a été dit que les femmes doivent prouver
Freedom's
leur
position was that this
pour montrer
particular
qu'ils
position
contribuent réellement.
requirement to prove contribution was contrary to the constitutional principle of equality that is contained in the Constitution of Kenya 2010.
Donc, à
The
partir
Constitution of Kenya provides that
de l'article,
this
il
is
y a
Article
l'exigence de
25
prouver la
3,
contribution.
that
C'est
parties to
contraire au
marriage
principe
at the point
constitutionnel
of
d'égalité contenu dans la Constitution
contracting the
de
marriage,
2010.
during the marriage, and at dissolution would have equal rights. It doesn't extrapolate what those equal rights look like.
Vous savez, ils
But the
doivent avoir
Matrimonial
des
Property
droits
Act is seen as breathing life into
égaux.
Article
On ne doit
55
pas extrapoler.
of that constitution.
Cela n'extrapole
Just
pas
a bit
en
of
fait.
history, Caroline, is that the question of the division of matrimonial property has been a very vexed question in this country because of the history in terms of where we come from in our matrimonial property jurisprudence and the law that we
Quand
used
ça
to
vient à la
apply.
jurisprudence
Carol, I'm getting some interference. I'm not sure if it's just me. Okay, I think it's
yes, Nyokabi, I think we appear to have, just give us a minute, we appear to have a problem with the French translation. Maimuna, has that been sorted out now?
Hello, there's supposed to be a Spanish translation as well, but I haven't been allocated as a translator, as an interpreter. Hello, can you hear me?
Yes, Sonia,
Yeah, hello?
I can hear you.
Yeah, so I'm supposed to
sorry.
be allocated as an interpreter, and I haven't been allocated yet. So you need to assign me as an interpreter, sorry.
Right, we are working on that. Give us a minute.
Yeah.
All right. I'll propose we carry on with the webinar. The French translation should be happening, and let us know in the chat box if you continue experiencing any challenges on that. For the Spanish translation, we are not able to set it up for now, and we apologize for this. And Miss Sonia, please bear with us. So we'll carry on with the English to French for now. Thank you so much, and over to you, Nyokabi. Sorry about the interruption.
No problem, Caroline. I'm glad that we're making sure we're carrying everyone along. So I'll just repeat a bit of what I've said just before the interruption, that by the time the Matrimonial Property Act was being passed, there had been a lot of contestations around how property should be divided upon dissolution of marriage. At the point at which the Constitution of Kenya was being passed, there was the expectation that women, because women are the ones who are disproportionately affected, would have equal property rights to men, both during as well as at the time of dissolution of marriage. So come 2013, and we have Section 7 of the Matrimonial Property Act, which requires that parties prove their contribution in order to be able to access a share of the matrimonial property. And this contribution was both financial as well as non-financial. This initially was hailed as a development because that was not the position in the law before. However, in effect, this position was actually discriminatory against women, and that was the core of FIDA Kenya's case. FIDA Kenya took this case to the High Court, invoking its
Este caso
constitutional
al
jurisdiction,
Tribunal
and
Supremo
asked the court to find that
y
in
les
view
pidió a la
of
Corte
Article 45, Part 3
que
of
en
the
vista del
Constitution,
artículo
as well as
45.3 de
other
la
provisions of law
Constitución,
within the
además de
International Human
otras
Rights Field framework,
disposiciones
Section 7, which required
del marco de los
people,
derechos humanos
especially women, to
internacionales, como
prove
la sección
their
7, requiere que la
contributions
gente,
in order to
especialmente
access a share of property, was
De prouver
discriminatory.
que cette contribution était à la
Especially
fois
when Jackson was
financière
looking
et
at
humaine.
Section 10
Cela a
of the
d'abord
same
été
act,
guéri,
which
a
provided
été
that upon
résolu.
dissolution of marriage, any liabilities that had been acquired during the marriage would be
Comme un
split on a
développement.
50-50 basis. So that was the position in court. The Attorney General who had been sued did not take this position. And unfortunately, the court did not
Parce que
agree.
je
And therefore, there was
n'étais
an
pas en
appeal
fait
to
à
the
la
Court of
position.
Appeal, which is the subject of today's discussion. At the Court of Appeal, FIDA Kenya reiterated this position, trying to demonstrate that in
Mais
effect,
en réalité, cette position
the
était en fait
requirement to
discriminatoire à
prove
l'égard des
contribution was
femmes. Et c'était
particularly
le cœur
difficult for women and
du
which
cas.
resulted in discrimination against them.
On voulait
Because
demander au
as we know,
tribunal de
it's extremely
constater qu'au vu
difficult
de
to
l'article
prove
45.3 de
forms
la
of financial
Constitution ainsi que
contribution.
d'autres
And
dispositions
secondly,
de la loi dans
it's
le
very
cadre de la
difficult to
section
prove
7
non-financial
internationale des droits
contribution.
de
And certain
l'homme
examples were even
qui
provided in
oblige
court.
les personnes,
Some
en
of those examples
particulier
were,
les
for
femmes,
example,
à
if you
prouver
say
leur
it is childcare,
contribution
how do you
afin d'accepter
quantify
la
that I
propriété.
took time off work to take care
En
of the
fait, comment
child?
est-ce qu'on veut que la
What is
femme
the metric with
quantifie
which we use to measure that?
le temps de travail qu'elle a eu à faire dans
The Initiative for Strategic
foyer?
Litigation in Africa was joined as an amicus, both at the High Court as well as the Court of Appeal, to also demonstrate the challenges with the requirement to prove all forms of contribution, to be able to demonstrate that the law, while it looked neutral,
On a fait un
particularly
appel pour
affected women
démontrer également les
who a
défis
lot of times find themselves
avec
being
l'exigence de prouver toutes les contributions, toutes les formes de
especialmente con las
contribution
mujeres.
pour pouvoir.
Sorry, it's probably me because I was assigned as an interpreter and I was interpreting, and then suddenly this has come off.
Sonia, thank you very much. Please let the webinar carry on. And
Donc, je suis censée traduire en espagnol.
We don't need Spanish interpretation.
Okay, no problem.
Mais on ne m'a pas assigné. D'accord, pas de problème, merci.
Nyokabi, back to you.
Thank you, Caroline. So as I was saying, is that at the High Court, FIDA gave certain examples, but ISLA which had also been joined as an amicus, that is a friend of the court, both at the High Court as well as at the Court of Appeal, demonstrated how international human rights law also requires courts to take what we call a substantive equality approach by not requiring strict proof of contributions and problematizing why contribution, when used as the only determinant to distribute matrimonial property, was extremely problematic, and how it particularly affected women, because women are the ones who find themselves doing domestic labor, often doing unpaid care work within the home, and that is more often than not, never quantified. Part of what both the amicus as well as the appellant demonstrated to the court was the challenges that had happened since 2013 when the law was first enacted in terms of the interpretation of Article 45.3 of the Constitution of Kenya. What we had seen as within the litigation and the jurisprudence that had been emerging both from the High Court and the Court of Appeal was really a mishmash of very many things. On the one hand, some courts took the view that Article 45.3 recognized that there was a problem in requiring contribution, but said that in as much as we do not have a metric to determine what sort of what contribution is how much, Article 45 as well as Article 27, which is our non-discrimination clause in Kenya, required a 50-50 split of marital assets upon dissolution of marriage. On the other hand, many courts also took the view that Article 45.3 did not require a 50-50 split, with some courts going as far as saying that to take such a position would be to imperil the institution of marriage. By the time this particular litigation was coming to the fore, we had, again, a plurality of laws, because there were some cases that were being undertaken under the Married Women Property Act, which required contribution, but also under the current Matrimonial Property Act. But this particular litigation had specifically to do with the requirement of contribution within the Matrimonial Property Act. After many years of litigation, the court did not agree with the appellants. The court found into two particularly critical things. That first, the institution of marriage by itself did not entitle any person to a beneficial interest in marital assets. And secondly, that the requirement under Section 7 of the Matrimonial Property Act, that is that everyone is required to prove their contributions to be able to access a share of matrimonial property, was not unconstitutional and did not violate either the national constitution in terms of the equality principle or any form of international human rights law. And it said that this particular section, especially when read with Section 10, remember Section 10 spoke of the distribution or the equal split of marital liabilities, that those two sections, when read together, actually amounted to fairness in terms of what somebody brought in. Part of what the court was saying was affirming the decisions of previous courts say that marriage does not entitle a party to any marital asset, that you still have to prove how you contributed to that. And the court did not address issues around the lack of a metric to prove non-financial contribution.
Thank you so much, Nyokabi, for that capturing and well reflection on what happened in the matter of FIDA Kenya. In its judgment, and I think you correctly pointed out that the court recognized that the institution of marriage itself does not amount or does not guarantee a spouse in the marriage of an automatic 50-50. Now, the court went further and said that one must actually establish the contribution they made so that they can be entitled, and the court can be able to see what it is that they are entitled to in the share of matrimonial property. So Justice Yeshetu will bring you here and ask you that when the court did conclude that the requirement to prove contribution does not in any way contravene the principle of equality, because the requirement to prove contribution is an evidentiary issue, that the court has powers and has the ability to determine, per the evidence that is given, what is the value and how it can quantify the contribution made. Then what is the impact of this particular finding on cases that require women to prove their non-monetary contribution? Does it in any way place any undue burden on women? And why is this actually a women's issue?
Thank you so much. Greetings, hello everyone from Addis Ababa, Ethiopia. It is a great pleasure to be part of this webinar, to share my insights and to listen the views, experience of others on this challenging issue of the share of or the distribution partition of matrimonial property during dissolution or divorce of marriage, which is actually a daily job of the judge. I read the case and I saw that the Kenyan Constitution, the 2010 Kenyan Constitution recognizes the right to equality of men and women under Article 27, and particularly under Article 45, sub-Article 3. The Kenyan Constitution provides that a man and a woman have equal rights during entering into marriage, during the marriage, and during dissolution of marriage, during divorce. This provision similarly exists in our legal system, and there's a challenge that raised by FIDA Kenya, the issue, the ground of appeal, particularly on the appellate court, that's raised by FIDA Kenya, was that even if this equality is the right to equality is recognized under Kenyan constitution, one as a principle that applies for all human beings, and the other particularly that's applicable on the spouses at marriage, starting from marriage and up to dissolution if divorce or dissolution occurs.
Parce que s'il y a un divorce qui se passe, les propriétés doivent systématiquement être distribuées au vu de la provision de la Constitution.
They have contributed towards the acquisition of the property, the rule of contribution.
Parce que les femmes n'ont pas à démontrer la contribution qu'elles rapportent.
14 years in the judiciary, from first instance to Supreme Court. What we observed on the judiciary so many times, frequently, is sometimes husbands own 3-4 houses, 3-4 cars without the knowledge of their wife. And in a marriage case, in a divorce case, usually,
souvent, il arrive que l'homme a plusieurs maisons en sa possession et plusieurs biens en sa possession à l'insu de sa femme.
For instance, parties have to identify, to establish the property under
En fait, nous devons tout faire pour identifier et établir une loi qui va démontrer la possession des biens de l'homme.
We don't require such requirements.
Malheureusement,
the party who alleges
on est toujours en attente de cela.
Lists down the property, and also in addition to listing the property down, they can also ask the court to investigate the bank account that exists by the name of.
Je pense aussi, en dehors des possessions de maisons et autres biens, on doit demander à la cour de vérifier les comptes en banque des époux, investiguer. Donc la cour doit investiguer sur les propriétés.
And when we made such investigation, I remember.
Je pense que quand nous faisons cette investigation, cela va nous aider à savoir le nombre de propriétés que l'homme a pendant leur année de mariage. Donc souvent, même si
they may not even know that they acquired the property. Usually,
donc tout ce que la femme sait faire en fait de façon générale, tout ce qu'on lui a dit, c'est qu'elle doit juste prendre soin de la maison et c'est tout. Elle ne doit pas en fait rentrer dans investiguer, alors que ceci n'est pas le cas.
Especially in the rural community, husband is a breadwinner, husband works outside, and also wives work at home. They contribute from different sides for their marriage. So I think when we see the reality on the ground, the lifestyle that the community actually exercises, and how they own property, how they manage property, I think proof of contribution. When we literally read Section 7 of the Matrimonial Act 2013, the literal reading of Section 7 may not have discriminatory words or provisions. But when we implement it on the ground, I think this has a discriminatory content. It will produce discriminatory outcome. The burden of proof in a court litigation, in a civil proceeding, is very important. Once a certain fact is alleged by plenty for defendants, the existence of like presumption of like common property, the absence of legal presumptions, the entire duty to prove, especially in the case I mentioned, the situations where the wives do not know that even their husband acquired some property while they are cohabiting. If they don't know even the existence of the property, they can't claim their contribution. They can't claim their contribution. They can't prove their contribution. What type of evidence? What type of evidence they can produce? What type of witness they can call to show that they have contribution on the acquisition of property if they do not know even they have acquired some property during in marriage. So the other is the financial contribution, the monetary contribution. The law says Section 7 of Matrimonial Act provides monetary and non-monetary contribution. It's difficult to calculate and to convert the value of non-monetary contribution to monetary contribution. If they acquired, for instance, millions of USD, if the husband worked outside and acquired millions of USD, and if the role of the wife remain taking care of a single kid or 2 children, how can the court convert? I think even if the provision is literally not discriminatory, even if the provision is literally not discriminatory, effect-wise, it produces discrimination. I remember, I'll come back to Ethiopian experience later on. I remember such situation which there is one Rural Land Act, Oromia Regional State Rural Land Act. The Rural Land Act was now changed. It is amended. Literally, it had no any type of discriminatory content, and effect-wise, but the law in the long run, especially when we evaluate the long run effect of the law, it happened to discriminate against women, particularly in rural land inheritance. As a result of these critics, the law has been amended before 2 years. I remember situation. I think this Section 7 of Matrimonial Act has such content, hidden latent systemic discrimination against women on its long run effect.
Okay. All right. Thank you so much, Justice Eshitu, for that disposition. And we appreciate you sharing your experiences from the bench with the audience present. And now, Professor Brenner, I will move to you next and ask that the court, in its decision, held that equality does not always mean identical treatment. And the law on proving contribution does not contradict Kenya's legal obligations and international law in any way on the basis of gender equality, because the law protects both spouses. This therefore raises concerns about the application of the gender neutral laws and their impact on the elimination and the state's duty to eliminate discrimination against women. So my question to you is, why do the laws that appear gender neutral in word and in their wording result in unequal outcomes? And then after that, I'll ask another question. You can answer them both together and tell us, like, okay, let's answer that one first and then come to the second question.
Thank you so much, Caroline, and thank you, colleagues, for the opportunity to be with you today. What I think I'll do is make some comments about the idea of equal treatment, and then I'll you some further reading on which I've relied in trying to make my comments and develop my thinking on this, and I'll put those further readings in the chat when I finish speaking. So the starting point for me is to look at the literature on equality and to look particularly at the critiques of notions of equality. So I would start here with Sandra Fredman, whose work many of you will know, who has called equality an ideal that shines brightly in what she calls the galaxy of liberal aspirations. So many human rights charters, constitutions, Kenya is one of them, tries to capture this ideal in legal form, in the form of some kind of equality guarantee, which, as colleagues have described, also exists in the 2010 Kenyan constitution. And that's captured in this phrase that we seek to treat like with like. But of course, we know that in practice, equal treatment can perpetuate inequality. So, for example, a law that on the face of it treats everyone the same can affect rich people and poor people differently. And that's captured in Anatole France's phrase, which I like to use with students in particular, which is this description of the majestic equality of the law. He says, forbids the rich as well as the poor to sleep under bridges or to steal bread. But of course, this is nonsensical. The rich never need to sleep under bridges or to steal bread. So there you have a seemingly neutral application of equality of the law, but of course it has differential effects. And Fredman points out that the idea of equality of treatment is predicated on this idea that justice is somehow served by consistency, whereas in fact, the mere fact that a rule treats everyone the same isn't a guarantee of equality. Why? Because differences in circumstances produce different effects, whether these are material effects or whether they are symbolic or kind of recognition effects. These differences in circumstances can be the product of historical patterns of disadvantage. So for us, the key is to try and think about how do we recognize patterns or cycles of disadvantage? And then how do we think about how those disadvantages come about? Do they come about because of the operations, for example, of the market? Or do they come about through the operation of private structures such as the family? How do these patterns of advantage and disadvantage reveal themselves? And that is a matter of keeping track not of individuals, and of course we know that the law operates to individualize, but it's to try to persuade the courts and others to think in terms of the effect on groups. So what is going on here in terms of structural effects, structural impacts, and therefore what is needed in terms of structural change. So unlike formal equality, those of us who make the argument for substantive equality recognize that detrimental consequences can attach to having a particular status. So, for example, being a person with a disability or being a woman can come with it certain consequences, which may need to be addressed. The aim of substantive equality, therefore, is to correct that disadvantage, or to correct for the fact of this experience. So, for example, to take into effect the deprivation of a genuine opportunity that a woman might experience or a person with disabilities might encounter. So that substantive equality, when we talk about it, is essentially redistributive in its aims. It's trying to redress disadvantage.
Yeah. Okay, Prof. Yeah, so Article 70 of the Maputo Protocol adopts what we're calling now the standard of equitable share as the basis for distribution and division of matrimonial property upon divorce. I hear you're speaking about substantive equality and how it can come in to remedy the harsh effects of a gender-neutral law, like what you are seeing in Section 7 of the Matrimonial Property Act. Then my question to you would be, how then can we realize the notion of substantive equality in relation to division of matrimonial property in Africa?
That's a perfectly timed question. Thank you, Caroline. The answer really builds on everything I've just said. So if we take seriously that substantive equality has to be redistributive in some way, it needs to redress disadvantage, then it follows that we need to think about what those disadvantages might be. So, for example, in relation to matrimonial property, we need to think about what are the disadvantages caused by the burdens of household labor, for example, falling disproportionately on women rather than on men. Well, how does that happen? And here I think there are various literatures that we can go to and analyses that we can utilize to understand how, for example, household labor falls differently and how, as a result of that, much of the contribution that women make is unseen or
le taux de la contribution que la femme rapporte dans un foyer.
Who alerted us to this question of our job as feminists is to make visible labor that is analytically hidden from us by classical economics, but it's also politically denied by policymakers, and in fact, it's very much denied by our courts.
Je sais que c'est quelque chose qui est lié par nos cours. En fait, on veut comprendre si l'apport de la femme dans les travaux domestiques rapporte un grand apport à la société.
And who points out that social reproductive work is in fact unique because it engages in motion. And it's invisible, partly because it's seen as being given out of.
Vous savez que c'est une chose qui est presque invisible de quantifier cela.
And important to quantify. And so to do that requires government action, and it requires.
Et pour changer cela, nous avons besoin de l'action du gouvernement.
Deep-rooted practices and assumptions that construct inequality, and that seek to find remedies to these ongoing harms that are done. So we need to persuade our courts, for example, to think about setting the material consequences of unequal labor in the household, for example, in a much broader context in order to understand the damage that is done to women and their prospects by having to carry out this kind of unrecognized labor. So in relation to achieving substantive equality, in relation to the division of matrimonial property, you would have to say we need to move beyond formal equality on paper. And to do that, we need to recognize non-financial contribution and what that might be. And the courts need to understand that these contributions are relevant when they are trying to quantify what a woman might have given up and how she might have indirectly contributed. So I'm thinking here, for example, and I'll just do this very briefly, the long-term economic disadvantages that women might suffer because they take career breaks in order to provide childcare, the fact that they sometimes are involved in part-time employment or even employment that's very, very difficult to evidence, informal employment, that they may relocate because of a partner's career, and also, and importantly, that they may be doing labor that's entirely invisible. So I'm thinking here about the kind of labor of running a household, and I attribute this literature coming to my attention to my colleague, Dr. Mariam Kamunya, who's here with me in Cardiff as a British Academy International Fellow, who's talked to me about this idea of cognitive labour, the idea that a woman needs to think about keeping a household on track, making doctor's appointments, anticipating needs. These are all invisible forms of labour that women perform, but that are really difficult to bring attention to and then to persuade our courts to quantify. And it's those sorts of non-monetary contributions that I would urge us to pay attention to, and the structural harms or effects that they have.
Thank you. Thank you so much, Prof, for sharing that with us and trying to make us understand how we can achieve the notion of substantive equality and how that can be assisted to move away from the requirement to prove and establish contribution. In Africa, we say that if you want to walk faster, you walk alone. But if you want to go far, you go with others. It is at this point I will move on to Mam Sheila. Mam Sheila, the Ghanaian law and the Ghanaian courts have adopted what we can say is a transformative approach in the issues and in the area of division of matrimonial property. I will now ask that you reflect on that and you share with us what has been the Ghanaian experience, the Ghanaian Supreme Court, and how have the courts adopted the substantive equality approach in the area of division of matrimonial property in order to realize fairness, equality, and non-discrimination.
Thank you very much, and greetings from Ghana to everyone. And I'm thankful to be part of this very important seminar. So with regard to the Ghanaian courts and then Ghanaian law and how women's property rights have been treated, it's been a long history. We started off at the time of independence with a position that whatever woman contributed towards the acquisition of property of a husband was the sole property of the husband. This was in 1959. And it is important to remember that in Ghana, we have a plural legal system. So our law recognizes the customary law marriage, it recognizes the Islamic marriage, and it also recognizes the civil type of marriage. So we have cases in which the courts at that time indicated that whatever woman and her children held the husband to acquire was his sole property. Sometimes equitable principles would be used to try to help some women. Then in the 1970s, things changed. We had the Matrimonial Causes Act of 1972, Act 367, and Section 20 of it deals with property settlement. So this is the law that deals with divorce and ancillary reliefs. So under Section 20, the provision indicates that the court may order either party to the marriage to pay to the other party such sums of money or convey to the other such movable or immovable property as settlement of property rights, or in lieu thereof, or as part of financial provision as the court finds just and equitable. It goes on further in Section 21 to say that where a decree of divorce or nullity is granted, the court is satisfied that either party to the marriage holds title to movable or immovable property, part of all of which rightly belongs to the other. The court shall also order transfer or conveyance of, interest to the other party. And in applying this principle, the courts adopted what we call the substantial contribution principle, meaning if the property is in the name of the husband, which is sort of like the norm in Ghana, and a wife says she also contributed to it, she had to actually bring evidence to prove it. And usually, if there's cash, she can prove, financial contribution. That is the easier way. But the courts had also used equitable principles to look at other means by which a woman could show her interest in contributing based on the evidence that is offered. There are instances where it's like, the woman pays school fees whilst are billed, etc. Some of these cases came to the courts. So these cases it's not been easy. Under the substantial contribution principle, it's not been easy for women. Then in our 1992 constitution, our fourth Republican constitution, a provision was introduced. Article 22 came up with the property rights of spouses. And it partly reads that Parliament shall, as soon as practicable after the coming into force of this constitution, enact legislation regulating the property rights of spouses. and with a view to achieving the full realization of the rights referred to in this clause, a spouse shall have equal access to property jointly acquired during marriage, and assets which are jointly acquired during marriage shall be distributed equitably between the spouses upon dissolution of the marriage. So the Constitution has been in effect since January 1993. This law has not come into being. So the court started applying the principles directly. There were a few cases that started applying it. But the classic case which really applied it was in 2012 in the Gladys Mensah versus Stephen Mensah case, which I'll talk briefly about. Because in that case, the Supreme Court actually laid down what we call the jurisprudence of equality, or equity is equality principle. And it's actually changed the landscape on the distribution of matrimonial property rights. So it's a simple story of a woman who was illiterate and then who was married to an accounts clerk who worked within the government setting. But the woman was illiterate, but she was a trader, trading in foodstuffs. And the two of them also opened a shop, etc. And several properties were acquired, about 4 houses and plots of land were acquired. And after a while, the man took over one of the houses and moved his mistress in. So the woman filed for divorce. The man indicated that, oh, she was just a housewife and wasn't earning any income, and that she had even stolen part of his money, etc. During the trial at the High Court, the court didn't believe the husband. So even though the woman didn't call evidence to substantiate her claims, the man's own witnesses sort of provided adequate information for the courts to conclude that the woman actually contributed a lot. One of them, for instance, admitted that, oh, there was a shop that she would come for the money at the end of the day. She was also selling foodstuffs, etc., from her home and supplying to various people at the ministries. So the judge found that, in fact, she had actually contributed, and they ordered at the High Court that there should be equal distribution based on her contribution. The Court of Appeal upheld this particular claim, but then the man also went to the Supreme Court. So the Supreme Court looked at all the facts and the evidence and traced the history of Ghana's history when it comes to matrimonial property rights from the 1959 case through the substantial contribution cases, and made a reference to Article 22 of the Constitution, noting that, yes, Parliament hadn't come out with the law, but it was indicated that it was time that the court started applying those provisions. In addition, the court also referred to Article 33(5) of our Constitution, which says that, which extends constitutional protection to rights not specifically enumerated, but inherent in a democratic society committed to human dignity. So they kind of introduced into the, applied international human rights directly. And then they expatiated on what became known as the jurisprudence of equality principle. And this principle simply says that it's defined as the application of international human rights treaties to domestic cases involving discrimination and violence against women, ensuring equal application of the law across all spheres of life. So reference was made to a number of international instruments, including CEDAW. And one of the key findings of the court, they also looked at other cases, even including some Kenyan cases, etc., etc. One of the key passages in the judgments, which is key, is that the court held that even if Gladys, which is the woman, had made no financial contribution whatsoever, and even if Stephen, that's the husband's version of events, had been entirely true, she would still be entitled to an equal share because her cooking, her laundry, her childcare, her maintenance of a stable home created the conditions in which the husband was free to go out and build an economic empire. This, according to the court, is a form of contribution. It is not invisible. It is not worthless, and the law must treat it accordingly. The court therefore dismissed the man's appeal, affirming what the other courts had indicated. And among others, this Supreme Court case used this case to institutionalize the equality is equity principle. It declared that the court of Ghana can no longer discriminate against women in the distribution of marital property. The substantial contribution test, that's, was like a gatekeeping mechanism that asked women to prove their worth in cedis, in currency, in financial terms, was effectively displaced. In this place, a presumption of equal partnership grounded in the Constitution, in international human rights, and in basic human dignity was affirmed. So as far as I'm concerned, this case matters because it names something that Ghanaian law had long struggled to articulate clearly, that marriage is a partnership of equals, that domestic labor has economic value, and that the dissolution of a marriage cannot lawfully be used as a mechanism to strip a woman of everything she helped build, whether or not she had a pen to the account books or not. So it's very important that the precedent that was set by this court is very important. It hasn't been fully followed in subsequent cases, I must say, but most Supreme Court cases would still refer to the equality is equity principle, but they've tried to kind of sort of put some additional conditions to it. In some of the cases, for instance, it's been indicated that so it's still a presumption. There's a presumption generally.
Qui indique que ça c'est une présomption.
It's supposed to be owned by the couple, and then it should be equitably distributed. Currently what the courts are saying is that depending on the type of evidence that is adduced by the party who's claiming an interest in it, then a decision will be taken as to what portion. So in a way, they are not using the equality is equity principle fully, even though they keep reciting to this case, but they're kind of dwindling what this case established, and that is a sort of worry to some of us. And in a recent case, I'll just quote very briefly from a recent case that came up in the courts, where the court said that they will not automatically. So what the court said is that in settling matrimonial property rights, it says that it implies that once a couple could adduce evidence in respect of their respective contributions to the acquisition of the jointly acquired properties, it would be inequitable for a court of law to order equal distribution in spite of clear evidence to the contrary. So they are sort of changing it a bit, and we are not really happy. And the advocates in Ghana are trying to see what can be done to reinstitute the original version. Thank you.
Okay, we'll come back to that later, Ma'am Sheila. But thank you so much for sharing the Ghanaian experience that demonstrates the powers of the court when the court understands the social context in which the law operates and how it can use its power to reform and cause an impact on institutional and institutional on the law and also in the society. Building up from that Ghanaian experience, I would like us to come back to Justice Eshetu. Justice Eshetu, you had spoken earlier on today in your experiences from the bench and the Ethiopian court's approach on the issue of division of matrimonial property. Now, I would like you maybe to reflect and tell us how have the courts in Ethiopia approached.
Thank you so much. Is my sound audible? The Ethiopian experience is Ethiopia is a federal state where there is one federal family code that is supposed to be applied in Addis Ababa and Rida, the two federally administered cities, and regional state family laws. Despite diverse family laws in the country regarding division of matrimonial property, the laws have similar content. In addition to that, there is precedent developed by Federal Supreme Court Cassation Bench on already a statutorily enacted law. And the law says presumption, the law establishes presumption of common property. Article 63 of Ethiopian Family Code, the Federal Family Code says, all property shall be deemed to be a common property, even if registered in the name of one of the spouses, unless such spouse proves that he or she is the sole owner thereof. This presumption of ownership, the presumption extends to the property that is registered by by the name of one of the spouses. I think the presumption has significant role in promoting the equal share of marital property. The case that I tried to mention, the situations that I tried to mention, the situation, the scenarios in which the wives do not know that their husband possessed some types of vehicles, some types of immovable houses. Such situation can be well governed from women equality rights by the presumption of common property. When, as a judge, you hold the presumption of common property at hand, the presumption of common property at hand, it shifts the burden of production of evidence and the burden of persuasion to the party that claims, to the party who claims that some property is the sole property of his own or her own. This presumption, I think, better serves the court also during hearing the partition of property. The partition of matrimonial property has always challenges. It's full of challenge. There are many grievances, but especially from equality perspective, if, for instance, the land is possessed by the husband and the wife built houses after concluding marriage, while in marriage, even if the property is registered by the name of the husband, without showing contribution, her own contribution, by merely showing that they possessed the property during a marriage, they acquired the property during a marriage, the woman can be entitled to the share of the property. Even the party who claims a property is matrimonial property need not explain and need not prove the means of acquisition. The party has to allege and prove the existence of property, even if it is registered by one of the spouses. And the other party who claims the property belongs to him or her solely has the burden of proving the means of acquisition. The means of acquisition that entitles the property for a single party, for husband or houses, showing the properties acquired before marriage, showing that the property is acquired from marriage, showing that the property is not integrated to common property through contract of marriage, or showing that the property is specifically given for one party by donation or succession while in marriage. These are the only exceptions through which the party who claims a property belongs solely to him or her can prove that the property is a personal property of the spouse. Otherwise, the law promotes common property. The judicial experience also shows that the judicial practice from the lower courts to the Supreme Court shows that the existing judicial practice promotes, reinforces the common property, the presumption of common property. Under Article 62, particularly, the Federal Family Court says all income derived by personal efforts of the spouses or from their common or personal property shall become the common property of the spouses. It further says all property acquired by the spouse during the marriage by onerous title shall be the common property unless declared personal. Onerous title means when a personal property is sold and changed to some type of property, unless this property is specifically declared by property registering before property registering institution as personal property, it will fall down in the paradigm of common property. So the Ethiopian experience, the law and the judicial experience promotes common property. And I think from this perspective, the existing court practice reduces the burden of proof for the wives, I think. Thank you.
Thank you so much, Justice Eshetu, for that. And we see how the Ethiopian courts and the law is contributing to the principle of fairness in distribution of matrimonial property. I will now move on to Professor Maji. Prof, South Africa has been deemed as one of those countries with a progressive and transformative constitution that is big on equality and social justice. What is then the South African approach to the issue of division of matrimonial property? And would you say, in your view, that this actually achieves the notion of substantive equality?
Thanks, Caroline. I think I might take this opportunity actually to just to elaborate a little bit on examples that we could use that are good examples from Southern Africa more generally, of how courts have approached ideas of fairness and substantive equality. And I think I might do that. We could come back to South Africa in particular, but it's an example that's really very well known, whereas I think probably our audience knows less about other jurisdictions. And I'm thinking here particularly of an interesting case from Malawi that I thought I might just quickly go over as an example of how the courts made particular efforts to think carefully and creatively about equality. So I thought I'd say a little bit about the Malawian case of Tuesa, because this is probably less well known than it should be. So this is a really important decision on substantive equality and went a long way towards recognition of non-financial contributions in matrimonial property disputes. It's a case of the High Court of Malawi Family Division, and the judgment was delivered in 2020. And the case essentially addressed whether an educational qualification, and this is unusual and interesting, I think, whether an educational qualification obtained during marriage can be treated as matrimonial property or justify compensation to the other spouse, the one who didn't acquire the qualifications. So the facts here just quickly are that this couple were married for 2 decades under customary law. During the marriage, the husband progressed his career from primary school all the way through to a college lecturer. He obtained higher education qualifications, including a degree. His wife remained working in the home, and she, as well as performing domestic work, also supported the household financially through small businesses in the kind of way that we've often seen and we all know about. And then after obtaining his higher education, the husband filed for divorce, and the wife argued that she had supported him through the marriage to obtain the qualification, and therefore that she was entitled to some share of the value of the qualification. I think this case raises really interesting legal issues. The main question before the court was, can educational qualifications obtained during marriage be somehow considered matrimonial property? So this is taking our discussion of matrimonial property in an interesting and new, I think, directions. And the court's reasoning, I think, really deserves our attention. So the starting point was fairness as a key principle in distribution of property, marital property. That's important. And of course, the Malawian constitution guarantees women the right to fair disposition of property upon divorce. And then the second question is, well, what's the non-financial contribution here? And what the court did really creatively here was to recognize that a spouse's domestic work and support during a marriage are valuable contributions, even if they're not monetary. And more important even than that, educational qualifications have some economic value. So the court stressed there is property in this educational qualification that the husband acquired because it allows him to generate future earning capacity, increases his future income. But the court did clarify the degree itself is personal. It's not it's really interesting for us. So what does the court do in a situation where she can't take his degree or even half his degree and call herself, for example, half a doctor, but she can somehow get something from its economic benefits in the consideration of how the matrimonial property should be dispersed after the end of the marriage. So the court held the wife should be compensated for that contribution whilst in pursuit of his education, and then set out how this should be done in the form of the building of a house or compensation in monetary terms. But the case is significant because of how transformative and creative it was here. It recognizes non-monetary contribution, and it acknowledges that an educational qualification is a form of matrimonial property in the sense that it creates economic value. And then the reasoning of the court, and it's important for us to be aware of this, was that the wife had some beneficial interest or equitable claim in her husband's educational qualification, so long as the marriage subsisted. Now, what to do when the marriage no longer subsists? That beneficial interest on the dissolution of their marriage is somehow divested. She is divested of it, but she should be compensated for that loss through the distribution of marital property, the court said. So the judge acknowledged that somehow the principle of fairness should mean that principle of fairness is paramount, and it should mean that the distribution of property should take into account that economic value generated by the qualification. And the judge was really open, and I think this is why it's so important to draw colleagues' attention to this case. The judge was very open in acknowledging that what would be suffered by the wife is a significant loss if nothing was done by the court in regard to this educational qualification. The judge acknowledged that because fairness was paramount, somehow a way had to be found for the wife not to be left economically disadvantaged, having supported her husband through the process of getting the qualification. And the judge laid down really important principles about how this might be done. And he wrote, to ignore the contribution of the sacrificing spouse would be to work an injustice, an unfair advantage to the spouse who's gained the qualification and the degree without any obligation, and an unjust enrichment of that spouse. And so here you see the courts finding a really creative way of developing principles that allow the court to move away from strict financial contribution rules and much more towards equity and fairness. And I wanted Caroline to stress the importance of this case because I think it tells us an awful lot about what our courts can do to develop innovative, novel principles. And to me, that's a really important point for us to discuss as a group and how we promote and support that kind of work.
Thank you so much, Prof. And you have rightfully shared the Malawian court's approach and the way the court has given meaning to the intangible contributions that women make in the marriage that contribute to the welfare and wellness of the family. I was hoping that you would discuss with us the Constitutional Court of South Africa approach in the EB versus EL case, and what does the South African court say on the issue of division of matrimonial property. All right, Prof, we can come back to that as we get back. So I will move to Nyokabi. And Nyokabi, the English courts or the law that we currently have in Africa emanated from the English approach. The English courts and the English law has since been reformed. What then would you say is that we can draw from those reforms, and how can it inform our own work on law reform on this issue of distribution of matrimonial property based on contribution?
Okay. Thanks, Carolina. I've really enjoyed listening to the conversation. I almost forgot that I'm also a panelist. But I think one of the things that I think even as we reflect on where the English law is, maybe I'd like to take us back a little bit. We know that Kenya, like many countries in Africa, has a colonial history. And that colonial history has influenced in a large part laws, especially laws on personal law, and including bodily autonomy and integrity. When we were receiving this law in 1882, the law, the way it was crafted, and I think the way it was interpreted there, was that it allowed single women to possibly own property independent of their husbands, despite the fact that they were also considered sort of like chattels of their husbands. But it gave courts the authority to make determinations as to title or ownership of property by women. And it also allowed women who were not married to also have property. We received this law as a statute of general application during our colonial times, and this continues to haunt us to date, despite the fact that we have 60-something years of independence and what is considered one of the most transformative constitutions on the continent. So while that statute was originally intended to actually delineate property rights for women, how we interpreted it, how Kenyan courts have interpreted it over time, and this is specific with Section 17, which now allowed the courts to make determinations as to how women or which property women own. Kenyan courts started moving more and more towards this contribution frame. So while it was in the statute, I want us not to forget that history around what it was intended to do. So when it was used in Kenya, it was being used to say, the English law was being used to say, look, you have to be able to prove contribution. And for a long time, up until around 2000, let me say 2005, the pattern that courts had taken was that you could take indirect or direct financial contribution, but you could also courts could also take into consideration proven what they're calling non-monetary contribution. And in cases, for example, like Kivitu versus Kivitu, where the court would actually say that yes, you could also take into account things like child care and domestic care. That was the position until the High Court was approached by a woman called Priscilla Esharia, who upon dissolution of marriage to her husband, who at the time was an ambassador, went and claimed a portion of a property that they owned, I think somewhere in Tigoni, which is it was a good property, a big property. And the court followed this line of saying that yes, it's okay, you could have this particular the direct the direct or indirect financial contribution, as well as the non-financial contribution. But the man in that case, Esharia, was unhappy, and he applied to the Court of Appeal for expansion of a bench. That was before the Supreme Court of Kenya. So a 5-judge bench was empaneled to listen to the one question as to what the correct interpretation of Section 17 of the Married Women Property Act ought to be. That case is what sets the ground for the conversation. It's like the historical foundation of part of the conversation that we're having today. Because in that case, the five judges unanimously held that under Section 17, the only contribution that could be considered was financial, so that you could prove direct financial contribution. So you can say, you can provide a payslip and say, I was working, and from the proceeds of my earnings, I contributed to purchase of our matrimonial home or other matrimonial property. Or you could prove indirect financial contribution to say that I was taking care of other things in the home in terms of the expenses, and therefore this freed up resources for the man to be able to amass this wealth. The Esharia case also had another angle. The property in question, the main property in question, was titled only in the name of the man. And part of what the Court of Appeal was asked to consider was whether or not the court, in determining a division of matrimonial property, could vary a title document, because now a title document is also governed under separate land laws. And the Court of Appeal said, no, there's nowhere in the English Act that allows to vary that titular document to find an interest for the woman. So the Court of Appeal decision in the Sharia versus Sharia now became the law. And for a long time, that was the law that eventually led us to the Married Women Property Act. The reason I've brought out that history is because of the question you've asked, how have the English evolved? In the Court of Appeal, when in the judgment of Sharia, and I'd encourage colleagues to read it, one of the things that the Court of Appeal decried in 2005 was that the fact that that Kenya continued to rely on the English law was, and I quote, a sad commentary on Kenya's law reform agenda to keep the country shackled to a 125-year-old legislation, foreign legislation, which England itself had found to be wanting. As at this time, 30 years earlier, actually 35 years earlier, England had already reformed its law to do away with the contribution frame. And there had been litigation that was also going on in emerging jurisprudence in England to evolve how distribution of matrimonial property was happening. So Sharia continues to be our law that has been affirmed by the Supreme Court in a decision called Ogentoto versus Ogentoto, where the court says that Sharia is good law based on the contribution frame, but it was also persuaded, the Supreme Court was also persuaded by a Ugandan decision called Rabinumi versus Bahimbisoy. I hope I've pronounced that correctly, but I'll put it in the chat box. But what the Supreme Court said there, that an individual's right to own property, even within the context of marriage, is not done away with by the institution of marriage. It's a problematic take because where we get our law from has since evolved. I've mentioned that there had been evolved jurisprudence. One of what is considered like the turning point was a case called White versus White. In this case, the English court moved away from this contribution-based framework, noting the difficulties that arose out of the requirements to prove contribution, whether it was financial or non-financial, but also just noting that marriage is actually supposed to be a partnership. And therefore, the court adopted what it calls a yardstick of equality, and says that when the court is trying to determine who owns what at the dissolution of marriage, it must take into account what now it's called the yardstick of equality, and this concept of partnership in marriage. In that yardstick, the House of Lords is very clear that there is no room for discrimination in effect in how the distribution of matrimonial property is done. So basically, you cannot discriminate against what it calls the homemaker or the bread earner or the child carer. Everyone plays a critical role in the sustenance of the marriage, and at the end of the marriage, then everyone has rights based on equality. This particular finding was affirmed upon in a decision called Miller versus Miller. I see some places where they call it /McFarlane versus McFarlane. And here, the court observed that marriage is a partnership of equals. So it affirms the idea from White versus White around the partnership of equals, and says that in the frame of equality, which now is non-discrimination continues to be a norm that everyone is bound. So it says that a partnership of equals then would require an equal sharing of marital assets, because every contribution that everybody makes continues to be extremely important. So there are three particular frames that the court in McFarlane takes that I find to be particularly useful. One is around the principle of equality mean redressing economic disadvantage. And I think Professor Manji has spoken a bit of this in the Tausa case, because the economic disadvantage that's suffered by a party during marriage has to be redressed at the point at which you are also dissolving that marriage. So that's the first frame. The second frame being the sharing, that partnership, I'm saying it's a partnership of equals. So the principle of equality would then require an equal sharing of the marital assets. And thirdly, it's to ensure that the needs of the spouses are met even post the marriage. You don't leave one particular spouse destitute over the other simply because they cannot provide documentary evidence. So that's the frame that we are in now, and it's encouraging to see courts that, like the court in Malawi, adopt in part such a frame, because it moves us closer towards advancing gender equality, both on paper as well as substantively.
Thank you so much, Nyokabi, for that. And we note that the English courts have actually come up with a framework that can guide the realization of the principle of substantive equality in the division of matrimonial property. I will come back to all our panelists now, and in 3 minutes, I would like to hear reflections, each one of you, and starting with Professor Maji. Professor, we have English court, you have spoken court approach that has actually realized and has made the notion of substantive division of match. How would an ideal law on division of matrimonial? Go ahead, Prof.
Sorry, Caroline, it's breaking up slightly. I hope you can hear me okay. Can you?
Yes, we can hear you.
Oh, good. I'll assume that you can. Okay. So just very briefly then, I think two key points that I want to make just in closing and wrapping up some of our remarks, and I found it extremely helpful to hear in your company's summary of how we can encourage models to move in particular directions. Two key points. One is the encouragement of a presumption of equal sharing of matrimonial property or marital property. So try to adopt legal frameworks where property which is acquired during marriage is presumed to be jointly owned, and regardless of whose name is on the title, and then a kind of default rule of equal division unless fairness requires some kind of adjustment. But many countries are in fact applying this principle in using community property regimes, for example. And then the second thing, and this comes back to the Malawian case I was discussing, the need to encourage the sort of gender progressive judicial interpretation that we've been talking about today. So assisting judges to think about how to interpret property laws, in particular marriage laws as well, in ways that address structural inequality. So that there's a real need, continuing need for judicial training on gender bias. There is clearly a need to set out explicitly how there is economic value in unpaid work, and it's a little bit difficult to do that job of quantification, but that is a duty of the court. It mustn't shy away from that duty to quantify unpaid work. And then secondly, that finally, that the courts need to be aware of power imbalances potentially between couples. I'm thinking here of more and more recent debates on economic abuse in marriage, and recognition by the courts that economic abuse has long run implications for a couple, and to train our judges to be alert to to be aware of what economic abuse looks like within a marriage. That's something we haven't completely touched on today, but I think it's implicit in what a lot of us are saying.
Okay. All right. Thank you so much, Prof. And building up into what you just said, that the bench and the members of the bench need to take into account the invisibility of women and the way they are erased by the law, and the failure by the courts that you have been seeing progressively over time to recognize women's contribution in terms of unpaid domestic work. I'll come to Justice Zeshetu, and I will ask, as a member of, what would be what would be your reflections on how we can actually actualize the principle of fairness, equality, and non-discrimination in the division of matrimonial property through the use of the courts?
Thank you. I think we have to work on understanding of equality, understanding of discrimination among the members of the judiciary, as well as on litigants to promote fairness, equality, and non-discrimination. We need to build a just society, particularly a just relationship between spouses. The need to build a just society starts from home, correcting the relationship between spouses. I think we have to make sure that the system that we put in place match with this fundamental principle. We have to question our system. We have to monitor, evaluate our system from different perspectives continuously. And from the victim perspective, the victim of injustice should not silence a party who feels that I'm a victim of this decision, this judgment, I am a victim of this policy, should not remain silent until the party overcome the discrimination, the injustice. The party should take different policy alternatives, including litigation. Sometimes the judiciary may understand some legal problem and may partly acknowledge that this problem has to be corrected one day. But for the fear of public policy, past precedents, the judiciary should not, the judiciary may not take commitment to reverse the status quo. At that time, I think the party should use different alternatives. The party should use different time and different levels of the judiciary. The party should exhaust remedies from different levels of the judiciary, and even if exhausted until the end, the party should not remain silent, should continue to make the agenda of fairness, equality, non-discrimination, state agenda, the agenda of the judiciary, continuous agenda of the judiciary, so that one day was the some level of the judiciary rejected, some level of higher level of the judiciary may accept, or what has been rejected today may be granted tomorrow when the understanding of the judge, the capacity of the system increases. And I think working on the competence or on the understanding of the members of the judiciary is also equally important. The member of the judiciary has to be progressive. They have to understand problems and promptly react to the problem, because the judiciary is one means of accessing the state. A party who feels that what the state did affects my rights, excludes me, discriminates me, can access the state through the judiciary. So the judiciary should also reconsider. This is my reflection. Thank you so much.
Thank you so much, Justice Eshetu, and thank you for sharing your expertise with us. And Professor Manji has spoken about how an ideal law should look like. Justice Eshetu has built on that and told us how the judiciary can contribute to the realization of the principle of substantive equality in the area of division of matrimonial property. I'd now like to move to you, Nyokabi. As a strategic litigator, someone who gets involved in strategic litigation and advocacy, what then would be the legal or procedural reforms that would have to be prioritized to support a shift towards a law that recognizes substantive equality as a basis for sharing of matrimonial property upon dissolution of marriage?
Okay, thanks, Caroline. Caroline, beg your pardon. So I think the courts are really showing us the way. We've got good examples, well, from England, but also on the continent from West Africa and Ghana and from Southern Africa and Malawi. I do believe there's also a case in South Africa, but I need to look for it. But I think one of the things that we first must do is continue to challenge this contribution frame. I've said a lot about why contribution is challenging. And I think we can challenge this, we can attack the contribution frame in two ways. One, we must impress upon courts as well as society that non-financial contributions are equal to financial contributions. Unfortunately, in some cases, even in Kenya, they'll say that first we will take the direct a balancing based off of indirect the non-financial contribution. And really, the courts in England, the courts in Malawi have shown us that correctly, that actually these two forms of contribution are as important to building marital assets. Secondly, and this is now a state responsibility, if we are going to continue using this contribution frame, then we need to come up with ways to properly value non-financial contribution. I think a big part of why we are not able to value non-financial contribution is because of how society views unpaid care and domestic work. Kenya recently did a KEBS study, or the Kenya Bureau of Statistics did a study around the unpaid and domestic care work. And I mean, the figures that they gave were actually insulting to people who are engaged in domestic work or unpaid care work. So we need to properly quantify this so that we can also assist courts. And this is actually something that the courts are asking for. When we were litigating the FIDA Kenya case, it was a direct question from the bench. Is there anywhere in the world that we have properly valued non-financial contributions? Unfortunately, the answer is no, because it's a very difficult thing to do. And then now, having dealt with that, another thing that we must work towards is actually just doing away with the contribution frame altogether. It's very problematic. We cannot use it as the sole measure to determine how women access property at dissolution of marriage. Secondly, I think we need to clarify what the principles of equality and particularly substantive equality mean. We are enacting laws, and that's why I said this is such a critical conversation. I think on 8th we will be celebrating the laws that advance gender justice, but we need to really critically examine how gender-neutral laws are affecting women. What the purpose versus the effect of the actual law. I know that's a continuing conversation here in Kenya. I know it's in Uganda, but I think it's something that we need to do a little bit more. And one of the frames that we must be able to impress as litigators or advocates is a need for a substantive equality frame. We would not be starting from scratch. The African Commission has developed a general comment on Article 7D on what equitable sharing of property means. It's not a perfect document, but it gives us a lot of insight as into taking into account the historical injustices or the historical disadvantages that women face. And I think the third one is also about thinking through how women benefit from marital assets, even during the course of marriage, or then framed another way is how to redress the economic disadvantage that women go through because of being in a marriage. That's one of the things that we need to do, either procedurally. I know in some cases there there are procedures through which women can apply to court to access marital assets or to use marital assets. Unfortunately, the experience that we have had, and here I'll speak to Kenya, I'm very familiar with, it's almost an uphill task. So that's one of the things that as on procedure we need to currently work on, but also now think so that when it comes to the point of dissolution of marriage, you're also now thinking about what has the benefit of the marital asset been throughout the process of, rather the institution of the marriage, and also now when we're thinking about dissolution. So for me, those would be the three reforms that I feel are critical. There could be many more, but perhaps that is where we start. Thank you, Karen.
Those matter, and they're actually very heavily loaded. They're amazing, and they seem to provide a solution on how we can move forward on this issue. And at this point, I think I'll come to Ma'am Sheila. Ma'am Sheila, you shared with us the progressive and the good decisions and the Ghanaian court's approach on the issue of division of matrimonial property, where the courts basically have equated marriage as a partnership of equals without one's contribution being given more weight over the other in the Mensah versus Mensah case. I would then like to ask you, maybe you share with us and your reflection on how we can protect these gains that are coming from the Ghanaian court, because I recall you mentioned that there is an attempt or a threat to these gains that we have already made. The progress, the good approaches that takes into account the principle of fairness, equality, and non-discrimination. How can we, as African feminist women and women who are doing strategic litigation, seek to protect these gains?
So thank you very much. Many of the points that I had in mind have already been articulated, but I'll still repeat them. We can all see the challenges that various countries are facing, particularly when it comes to issues to do with contribution, when it comes to issues to do with this whole presumption, rebuttable presumption, which, as I said, in Ghana, it's going, the decisions are going here and there, etc., etc. It sort of ends up in the scrutiny of a woman's experience during the marriage, and that is not fair because there are other things which is difficult to quantify in coming up with this, what is fair and what is equitable. Our Mensah case came up with a good principle, applied human rights principles, etc., but sustaining it has been a big challenge. So for me, I would say that we actually need legislation to try to address some of these, some of the thorny areas, to bring some certainty. It would also then make it easier for these principles to be applied even at the lower courts, because most of these cases we're talking about, people have to struggle from the lower courts to the Court of Appeal to the Supreme Court, etc., which is very expensive for the average woman. So we need to have something that will make it easier for the ordinary person, ordinary woman, to have access to the law. So I would push for legislation which would clearly articulate what matrimonial property is, because in some jurisdictions it's even an issue to determine what is the matrimonial property. It would also make what a contribution is or should be. In our Ghanaian, for instance, in the draft bill that we have, contribution is defined very widely, and I think that it's one of the reasons why the law never passed. It talks about a lot of the things we've spoken about, apart from the mandatory contribution, care for children, the aged, the infirm, giving up a higher standard of living, otherwise giving material assistance, management of the household, the performance of household chores, paying money, hereditary service, work on a spouse's farm or business. So for me, if we push for legislation that actually tries to capture a lot of the things women do in marriage, which sometimes is difficult to quantify, it would really help, and it would take into consideration what my colleague just spoke about, which is the value of unpaid work, etc., etc. So I think it is one means by which we can, as feminists, we can be able to try to push at a country level and even at the continental level to see whether we can have some kind of model laws that could be used based on good practices from other countries. I also think that as feminists, public interest litigation is a tool that can really help. I know, like in Kenya, it's being used. In Ghana, we use it a bit. We're not using it as much as we should, but we could use it also to push to get issues clarified. In Ghana, for instance, because our constitution says we need a clear law, which makes it easier and hasn't happened. Some of us some time ago tried to initiate some public interest litigation for a declaration for the Supreme Court that why has this law not come up? A few challenges hasn't really, but it's something that we should really push to get it done. And we need more research. Thirdly, we need more research to be able to document the experiences that people are going through. And if we share it on a continental level, lots of lessons could be learned that could help feminists to be able to push a common agenda, irrespective of which countries we are in. So I would say that a lot can be done to try to improve the situation. Thank you.
All right. Thank you so much, Mom Sheila. And I think I like the approach of undertaking research where we can share the lived experiences and the realities of African women so that it can inform the law reform and the laws that are being implemented and enacted, as well as the court when it's interpreting the law, that it can take into account the actual lived realities of African women. So I will now move on to the chat box and see the questions that are there, and then we can direct them to the specific panelists. And if you have a question, we have 10 minutes. You can put the question down and we can try to address it. So the first question, I think this is a comment. It's not really a question. It's by Dr. Ruth Nekula. Dr. Ruth, amazing webinar. Thank you, Dr. Thank you so much, Karen, all the panelists. The history and comparative perspectives are so useful. I'm realizing that occasional, that is positive jurisprudence, without a clear yardstick can be successful for a short time, then it starts dwindling, as it has happened in Ghana. I think we need to develop and innovate this metric, yardstick, clearly from an African feminist substantive equality. Maybe the courts are struggling because they don't know what alternative will replace this contribution framing. Thank you, Dr. for your comment, and this speaks to the members in the audience, the academia. We can take it up. Dr. Sheila, Mam Sheila has told us about documenting our experiences as African feminists that can be used. There is another comment by Shinta Jennifer, and our comment is most East African and Sub-Saharan countries are still predominantly rural, where land is assessed through family or customary law and residence is patriarchal. How is such property handled in the event of divorce, since it is often not possible to sell off such property and the husband might not be able to compensate monetarily? Even if the woman were to be allocated a piece of land on the husband's family land, she will face a lot of animosity and might not be able to live on the land. The focus is on acquired untitled property and ignores the nature of ownership in the context. This context, I believe, of community or communal land. I will ask Professor Manji to address that question, but as you carry on, let's go through. We see if there's another question. There is a comment by Christine Okeno. Can you please share the full citation of the Ghanaian case discussed? The case is Mensah versus Mensah, and I believe Mam Sheila has already shared the citation. There is a comment by Regina Kimwemo. Regina notes that the law is being discriminatory when it fails to recognize the inevitable contribution of women in the family. This is work like any other work. The husband cannot be able to do much if they were doing this work also. Therefore, taking care of the children and the family work is a huge contribution to the family income and property for that matter. They are actually complementary, and the author of the family intended that they should stick together so that the issue of who gets what should not be there. I believe that is a comment, and thank you so much, Regina, for your comment and for your observation. There is another comment by Akisi Konduyo. I hope I pronounced your name well. It is true that there is not proven it is not proven to justify that women have contributed, but why reconsider what is, I'm not sure I understand the comment, but the fact women permit men to learn the activity that produce. Maybe Akisi, you can give us your comment if you're still present. I'm not able to follow. And basically, Dr. Marcin Drecher, great engagement. See also the recent progressive dissent by Justice Ngugi in the Resma case. That is true. Justice Ngugi just gave a dissenting decision in one of the issues, on the issues that we're discussing today in a case that sought to distribute matrimonial property. Maybe I will ask Nyokabi to take a minute and mention about Justice Ngugi's progressive thinking, the approach that he developed and he adopted on unbundling and the undue burden that women have to face when they have to prove contribution. I'll come to you in a short, Nyokabi, but I think yeah, so let's take those ones first as we go through other comments. Moza Jadid, I notice your hand is up. I will ask Prof to answer the question and Nyokabi to make the comment, and then we can come to you. In 2 minutes each, please go ahead, Prof, and then Nyokabi.
Yeah, I'll defer to Nyokabi on it's a really interesting question about what to do in situations where land or compensation can't simply be allocated because it puts the woman in a difficult position vis-a-vis a family who are also resident on land. But I think it still, for me, raises a bigger question about how we make it possible for our judges to come up with creative solutions. So I think apart from that specific question which needs resolution, the bigger question is how do we encourage the courts to do that difficult work of not just recognizing the contribution, which is non-monetary, but doing the work of quantifying it when they don't. I think somebody said in the comments they don't have a framework for how to do that. And I think part of our job as progressive feminists who are litigating and writing and researching this is to think about what might be some of the frameworks that the courts can use to think about what is it that a woman is doing when she's contributing this labor. And I would refer us there to the work of Prabha Koteswaran, which I put in the chat. She's done some really interesting work on Indian courts in tort cases which involve road accidents, where a woman has died, for example, and her family is being compensated in tort. And the courts are having to think about, well, how do you quantify what her contribution was as a homemaker? And that's really difficult work for our courts to do, but it is possible to encourage them in a particular direction. And I would really recommend Professor Koteswaran's work in this regard. And I think we can learn from each other from different jurisdictions across the global south in how we try and do this work.
Okay. Thank you so much, Prof. Nyokabi?
Thanks, Caroline. I'm not sure I've gotten Regina's question very well because I think I understand her to say that it's difficult, like the marital assets should be for the family and the family is intended to be together.
Our question is that sometimes women find themselves in marriages that they do not have title to the property because the property is held in communal ownership. So in that instance, what is our view?
So yes, I'm actually going to say that, yeah, so that even if the family, the property is supposed to be for the family, I think we need to be realistic that sometimes the woman would want to break for that, or the woman will break from that family for whatever reason. And we need to be able to protect women when they are out of this institution. First, because marriage generally is a very patriarchal institution, but there's additional harm that can be done when a woman removes herself from there and then she's left with basically destitute. And I do think there's a general recommendation that deals with this in terms of the place of women or in economic relations, especially in terms of family. Because if a woman is working in a family institution or is benefiting directly from a family-owned property, then it becomes difficult. There are a couple of cases like this actually in the Kenyan courts, especially where they are in polygamous unions. But I think, like Prof has said, I think courts need to be able to come up with solutions. And here I think back to, this is a succession case, but I think back to this case in Kericho by Justice Nguge, as she then was, when in the context of a succession, but in a polygamous union, actually said that the first wife was entitled to be able to take out a portion of whatever it was she had contributed prior to distribution of the net intestate estate. It's something that is innovative, it's new, but now that has actually become the standard because of that recognition of, while this is family property, this person has actually, this woman had contributed something before in her own right, and therefore if she's to get out, then she cannot lose that protection. But just also,
thank you, Nyokavi. In the interest of time, I'll have to cut you short. You'll forgive me because we still have Moza's hand. And Moza?
No problem. Thank
you. Thank you, Caroline. My name is Moza Jadid. I teach at the University of Nairobi, and I also teach equality law. And I've also been litigating on indirect discrimination, substantive equality for the last 12 years. So I've had the panelists in the beginning. Yeah, I took a break, but I've come back. So from the 4 panelists I had, my take is we are all speaking on the same thing, but we have just divergent understanding. I think from the way I see Nyokabi talking about Section 7 and Section 10 of the Matrimonial Act conflicting, because Section 7 discriminates against women because it conflicts Article 45(3), and that Section 10 actually calls for equality of liabilities. And I find that's where from the beginning, from the High Court case, I knew it was wrong, it was going to fail. And when I saw the Court of Appeal decision, I also knew it's going to fail if that was the only argument you're making. So from that take, I gathered is that we are misconstruing what the word equality means. And I like what Professor Manje is saying, like as she mentioned, that the way the law treats everyone the same way is not necessarily justice. And that's exactly what it is. If we treat people in the same way, it's not necessarily justice. And what the word equality means under Article 45(3) and other provisions in Article 27, go to Section 7, Section 10, it does not necessarily mean identical treatment. So we confuse equality with identity treatment or identical treatment, and that's where the mistake is. So for me, my take, and I've written about the Matrimonial Property Act from the principle of equality. I've written about it. It's a paper that's going to be published in April. And I've also litigated over this for the last 12 years. Equality means many things. It may mean sometimes identical treatment, and it may mean sometimes different treatment. Different treatment, because we look, as you say, social context. We look at the position of the parties. And therefore, for me, Section 7 does not conflict Article 45(3), nor does Section 10 says liabilities will be shared equally, shared identically. It mentions equally. And therefore, if you take that the word equality under the Constitution and in the Married Women's Property Act means substantive equality, commensurate to the parties' positions, commensurate to the part. So in our case, it will be contribution. How much did they contribute to the liability? That's what Section 10 is talking about. Take liability according to your contribution. And how do you get acquisition to property? Again, under Section 7, according to your contribution. I think that's what the courts have decided, from the High Court up to the Supreme Court, the case of Ogentoto. That's what the court is talking about. So if you look at the Ghanaian case, the Mensa versus Mensa, it may have said what it said, but look at the jurisprudence that is not emanating from Ghana. They're saying there's a presumption, but that the property will be shared equitably. So again, we make a mistake between equality and equitable. And for me, and for where I said equity equals or is commensurate to substantive equality. And that's what we should, as women rights advocates, as equality law practitioners, let's extrapolate more the meaning of equality, and let's be open to hear the other view. And my suggestion was, I also see.
Thank you, Monza. Thank you.
Sorry, Caroline. Thank you.
I'm so sorry I have to cut you. We're actually out of time, and we appreciate your comments. They are noted, and I think it's important to we'll be on the lookout for the paper that you're about to publish on this work, because obviously it's going to contribute to the body of knowledge that exists on this issue. So thank you very much for your observation and for your reflection, and we appreciate your time to join us. So there's one comment I think that we cannot log off without addressing. Sandra, I see your hand. I'm coming to you, and I'm asking the panelists if you could please grant us 5 minutes so that we can wind up. Dr. Mariam Kamonyo, she says that she has enjoyed the webinar, and my position to the panelists, I just want to throw a caution on sentiment I've heard where the Kenyan court was requesting a framework on how to value non-financial contribution. Quantifying non-financial contribution in matrimonial property division is dangerous because it collapses what is already a guaranteed constitutional and statutory commitment to equal partnership into a market style of accounting exercise. Yet the market already systematically undervalues care and domestic labor. In practice, quantification will create a further evidentiary trap, since financial contributions are documented while caregiving and household management are often invisible and difficult to prove. This will push the caregiving spouse into arbitrary estimate and invite work judgment on what counts as work. This will obviously also increase inconsistencies in decision and unpredictable outcomes. Dr. Mariam, this is exactly what the case before the court was about, and the case before the court was to tell the court that the notion of quantifying both financial and non-financial contribution places undue burden on women, particularly, and it amounts to indirect discrimination, and contribution and quantification of contribution should not be the lens in which we understand equality and substantive equality in the realization of in the division of matrimonial property. So you are spot on, and this is the issue that we sought to address in the court. So thank you so much for your comment and the observation. Sandra, if you're still with us, you have a minute, please.
Yes, thank you very much for the opportunity. I think I want to second and echo the sentiments that have been posited here by Dr. Moza Jadid. I think in my perspective, we have misconstrued the principle of equality that has been guaranteed under Article 27 in the context of the Kenyan law, the Constitution of Kenya. Article 27 speaks to the principle of the Kenyan Constitution, speaks to the principle of equality. And just to echo what Moza has said, under Article 27, sub-Article 6, the crafters of the Constitution, noting that the equality principle, if we apply what is called the Aristotle principle of treating same things the same, alike things, which the principle states you treat things similarly, it will amount to discrimination. Noted in sub-Article 6 that to give effect to the realization of the principle of equality guaranteed in the Constitution, the state was mandated to come up with legislation and measures, including affirmative action programs and policies designed to redress the disadvantages suffered by various populations. And therefore, in that sub-article, there is a realization that for us to attain substantive equality, the differential treatment principle needs to come in, so that those who have been disadvantaged, whether in the private sphere, in the domestic sphere, can be able to realize their rights. This includes women in families. And therefore, that needs to be taken into consideration. Number two is this, that there can never be a formula for division of matrimonial property, in my view. Why? Is because if we do gender analysis, and I'm using the Harvard framework. There's a Harvard framework when you come to gender analysis, so that you look at the productive contribution, reproductive contribution, and community contribution, so that you'll be asking yourself, what did the man contribute? What did the woman contribute? And if we are to quantify or value that through valuation reports or any legislation that gives some quantification to the work done, like the Minimum Wage Act or legislation in Kenya, for example, then you are able to come up with certain values that can direct you to what contribution is. So it varies depending with what an individual contributed in a home.
All right. Thank you, Sandra. Thank you for your observation, and thank you for joining us for this webinar. And as you rightfully put it, there can never be a formula that takes into account contribution of the parties on equal basis. So marriage, and what I would like us to take away is that marriage is a partnership of equals. Each contribution made by each spouse to the marriage matters and should be taken into account and given equal weight at the time of dissolution of the marriage. That is what we are trying to do in the continent, and we are trying to have this conversation so that we can try to service some of the way the law is bribed. The law is not being seen or is not seeing the lived realities and the experiences of African women. So thank you everybody for your participation. Thank you for joining us this afternoon, this morning, this evening, wherever you are tuned in from. And thank you, our dear panelists. Thank you for sharing your expertise with our audience and for your time, and we remain grateful. And I'm your moderator. My name is Caroline. I work at ISLA, and I'm the Women's Socio-Economic Rights, and I lead ISLA's work on the continent on the Women's Socio-Economic Rights strategic litigation. So thank you, everybody. Have a good evening, good morning, good afternoon, and until next time, all the best.
Thank you so much. Have a nice time.